So the Supreme Court recently issued a decision denying emergency review in a case which was directly challenging New York City's controversial rifle and shotgun permit requirement, and this is now heading to the Supreme Court for round 2. Now, I wanted to let you guys know that this video is sponsored by SimpliSafe. This is the security system that I am currently using to protect my home and my family. And I wanted to let you guys know that there is no safe like SimpliSafe. As someone who obviously values personal security and safety, I want to protect my family and my home with the best possible products. And I can't stress enough the importance of a reliable security system that you can trust. SimpliSafe isn't just an alarm system. It's actually designed to protect you from all angles with sensors and cameras and professional monitoring that is ready 24/7 to actually respond to any situation. I personally love the indoor cameras, which I currently use to monitor and protect some of the more sensitive locations within my home. I also candidly use it to just spy on my cats when I'm gone. It's fun to kind of watch them. I also love their Active Guard outdoor protection, which I use to monitor the outside of my home. I personally believe that everyone should have at least one outdoor camera for the safety of their home. So SimpliSafe has a wide variety of products that you can get to protect your home and your family. And here's the best part. Right now you can save 60% on your SimpliSafe security system with a professional monitoring plan, and you can get your first month absolutely free. Just go to simplisafe.com/armscholar to customize your order. You can try SimpliSafe risk-free, and if it's not for you, you can return it within 60 days and get a full refund. Again, check out SimpliSafe using the links down below in the detail section and also in the pinned comment. And remember, there is no safe like SimpliSafe. As I mentioned in the intro, in this video, we're going to be discussing a very important rifle and shotgun permit case, which was recently denied emergency intervention by the United States Supreme Court. And as a result of that, this case has now been thrown out by the Second Circuit Court of Appeals. This case challenges the City of New York's permit requirements that must be met to possess a rifle or shotgun within the city. The case we're going to be talking about in this video is called Schroer versus the City of New York. Under this permit, the police department gets complete discretion on determining who meets the good moral character determination and ultimately who does not. So they have pure discretion in saying who gets a permit and who does not. The emergency application in this case was recently submitted to the Supreme Court, and the case was denied emergency review by the United States Supreme Court. The Supreme Court denied emergency review at that time because this case and decision was in fact pending in front of a 3-judge panel in the Second Circuit. So typically the Supreme Court will not get involved, especially when a Circuit Court of Appeals is set to rule on an issue. However, after that denial, the Second Circuit then decided to take a radical approach. After the Supreme Court decided not to get involved, the Second Circuit decided on their own to issue a ruling that ultimately mooted the entire case and then dismissed the entire lawsuit. This has now set the stage for this case to go back to the Supreme Court for a second time because the Second Circuit decided to play games and throw the entire case out. Now, this case involves a permit scheme that is in direct defiance to the Supreme Court's recent decision in Bruin. The plaintiffs argue that under Bruin, the Supreme Court struck down a very similar application process that was purely discretionary. The Supreme Court found that in Bruin, there was no historical support for may issue CCW permits, and now the plaintiffs in the Schroer case also argue that there is no historical support for a may issue firearms possession permit. So it's a very similar permit process. Instead, in Bruin, it had to do with concealed carry permits, but this has to do with a may issue permitting process for you to actually possess and purchase these types of firearms. And on review, the district court granted a permanent injunction against one of the provisions of the licensing scheme, and that was against the good moral character determination. So the court there found that the good moral character determination was in fact unconstitutional and permanently enjoined it. Now, that was a huge win, but of course, the City of New York was not going to let that stand, so they appealed up to the Second Circuit Court of Appeals. The City of New York also sought a stay of that lower court permanent injunction on the moral character determination, and the Second Circuit, of course, granted that in their favor. At that time, then, an emergency application was filed to the Supreme Court by the plaintiff Joseph Schroer because he wanted the Supreme Court to step in early and remove that emergency stay that was put in place by the Second Circuit. Essentially, he wanted the good moral character determination to be removed like the lower court ruled on. That emergency application was filed to Justice Sonia Sotomayor, who is responsible for the Second Circuit review of applications. She then sent it to the full court for consideration. However, the Supreme Court on full consideration, denied that emergency application. But that denial of the emergency application had huge ramifications for how the Second Circuit then reviewed and ruled on this case. As a result of that denial, I guess the Second Circuit felt free to do whatever they wanted, and they decided to then moot the entire case and rule to dismiss the entire lawsuit. New York argued that Mr. Schroer has received a permit since filing this lawsuit. New York argued that that ultimately means that he is seeking the type of relief that has already been granted to him, and therefore, since no relief can be granted to him, this lawsuit is now moot. The city of New York also argued that this entire lawsuit was invalid because the prior New York statute was then thrown out after Bruin and was changed with the Concealed Carry Improvement Act, which was passed after Bruin. So they argue that some of the basis that Mr. Schroer originally sued them on is now invalid because they changed the law. Ultimately, the Second Circuit Court of Appeals agreed with the city of New York. They decided to moot the entire case. In their order, they stated that we now hold that because Schroer has been granted the very relief he sought, the case before us is moot and we lack jurisdiction to hear the merits. They then went on to state that there is no indication that the city granted Schroer's rifle and shotgun permit to intentionally moot this case or even that its action was related to the lawsuit. Now, there are two main considerations to overcome mootness arguments like the one that happened in this lawsuit, one of them being that the party tried to moot the case intentionally, and the second is that even if the issue is moot right now, that there maybe is future injury that could recur. And so Schroer argued not only did the city of New York intentionally grant his permit in 2024 suddenly to moot this case, but also the city has still the power to revoke his permit that they just issued him or to deny his renewal of the permit when the time has come for him to renew that permit. The Second Circuit found that both arguments were unpersuasive, so they are essentially just trusting what the city of New York told them. However, the plaintiffs did not give up after that decision of the whole mooting of the case. The plaintiffs then sought en banc panel review in the Second Circuit, so they filed for a petition of a rehearing en banc. However, the Second Circuit en banc panel quickly denied the request for a rehearing. That denial by the Second Circuit en banc panel now clears the path for the plaintiffs here to go to the Supreme Court for a second time. The plaintiffs now have until January 15th to file for a petition in the Supreme Court for certiorari, and the time will essentially tell whether or not the Supreme Court will grant and want to get involved with this issue. But it's now interesting because after the original denial from the Supreme Court, maybe the Supreme Court believed that the Second Circuit would actually address this issue on the merits and actually look at this case based on Bruin, but the Second Circuit Court of Appeals decided to not do that. Instead, they mooted the entire case and dismissed the entire lawsuit to avoid actually looking at the Second Amendment question in this case. In Mr. Schroer's original petition for en banc rehearing, he argued that the vacatur of the decision, along with the mooting of the case for a lack of standing, is not in alignment with Second Circuit precedent. Essentially, the panel went the extra mile, not only to moot the case, but then also reversed the decision down below from the district court. He also argued that there is clear evidence that the city granted his permit in an attempt to essentially moot this lawsuit. Also, there is no guarantee that his permit will not be revoked after this case is completely thrown out, and there again is no guarantee that they will renew his permit once the time has run. So now the clock is ticking for Mr. Schroer to file for Supreme Court review. If he wants to have the Supreme Court petition filed and for Supreme Court to get involved, he has until January. The district court recently held a status conference on this case, and then after that status conference, dismissed the city of New York's original request to dismiss the case. Right now, there has been a request for a new motion to dismiss if the city of New York wants to file one, which likely they will. The city of New York is now trying to get the lower court to rule in accordance with what the Second Circuit said, and that might push the plaintiffs even more to decide to go to the Supreme Court now for a second time to get them involved and override what the Second Circuit said. So very interesting developments in this case, and it shows the ramifications of what happened after the Supreme Court decided to not get involved when the first petition was filed to them. And now, ultimately, I think this is going to make its way to the Supreme Court for the second time because the Second Circuit decided to dismiss and moot the entire lawsuit and avoid actually looking at the Second Amendment question in light of Bruin. So as we get more information, as more things develop in this lawsuit, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.